The doctor admitted to me during pretrial testimony that if the facts that we described were true, then his treatment would represent a departure, a violation from the basic standards of medical care. Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. It's a medical malpractice case, and now, during the course of the litigation, I had an opportunity to question the doctor that my client was suing. And during the course of questioning, I have an opportunity to ask him hypothetical questions. Doctor, I want you to assume that the following facts are true. And now I'll give him a list of facts. Assuming those facts to be true, would you agree that by doing X, Y, and Z, which is exactly what he did, that would be a departure, a violation from the basic standards of medical care? And he looked at me, he looked at his attorney, he looked back at me, he said, yes, I would. And then I said, tell me why, doctor. And now he proceeded to explain how that treatment, in light of the facts that we described, assuming them to be true, would in fact be incorrect medical care and treatment. And then I had follow-up. I said, doctor, would the patient have suffered injury if this were done? Yes, she would. What type of injury would you expect to see? And now he went ahead and laid out exactly the type of injury. And then I will ask additional hypothetical questions going down the line about facts that we believe are true, that we believe are supported by the medical records as well as other testimony in this case. It's critical for me as the attorney who represents the injured victim to ask the doctor hypothetical questions so that now at trial, a year or two later, now when we put on our proof, when we show to the jury all of the testimony and the evidence that we have to support our claim, if the jury believes what we have put on to support our claim, now I have the doctor's own words, so that if the jury recognizes and believes our version of the events, I can show to the jury, ladies and gentlemen, assuming that these facts are true, that you believe them to be true, that they took place, the doctor who we have sued, in his own words, acknowledges and admits that that treatment was inappropriate. And as a result of that inappropriate treatment, caused injury, and that the injury was significant or permanent. And that is the goal of an attorney who represents an injured victim, to be able to use the doctor's pretrial testimony to show to the jury, once they believe that our facts to be true, now it lends greater credibility and greater weight to what it is that we're claiming, for the jury to acknowledge and recognize, yes, you're entitled to a verdict because the doctor has acknowledged that what he did was inappropriate. So why do I share this great information with you? I share it with you just to give you a sense of what goes on in a medical malpractice case here in the state of New York. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have legal questions, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.